Good day, managing agents, and welcome to today's webinar. My name is Naledi. I'm the Stakeholder Relations for PPRA. If you can hear me, please give me a thumbs up before we continue. Advocate Vile, you can put the presentation on slide mode so long. Okay, they can hear us. Welcome, everyone. I think other members, they will find us while we're busy with the proceedings because I'm looking at the time so that we can be able to proceed. We are very excited to have, this webinar so that you can join us so that we can dive into the important topic of how to register managing agents and a slight overview on the PPA, because we know now with the new legislation, Advocate will just summarize it a bit for us. So in today's session, we'll be covering everything that you will need to know about the registration process, the necessary documents, the step-by-step procedure, the fees, all the insight that you will want to know and navigate, as you register after the webinar so that you find it with ease. Even if you are new, I think the webinar, it will assist. And even if you were a property practitioner prior, the webinar will assist because the categories are different and the processes thereof. So today with me, I want to introduce our expert presenter. Her name is Advocate Vile. She is the Executive Manager of the Licensing and Exemptions Department at the PPRA. She's also a Fidelity Fund Claims Manager, and she obtained her BA Law and Postgraduate LLB degree at the University of Natal, and she's been an admitted advocate for 38 years, and she spent more than 20 years as a prosecutor in the criminal and civil magistrate with the Department of Justice. She's been working in the private sector, public sector for over 11 years. And, she's been busy with litigations, and now she's in the registration. She's going to assist us in all the process. Please, without further ado, please allow me to welcome Advocate Deborah Vile. Advocate, I think we can start with the presentation. Thank you.
Thank you, Naledi. Welcome, everybody. It's good to be with you this afternoon. Naledi, can you just confirm that I am audible?
Yes, I can hear you. I can hear you, Advocate.
Thank you. Right, welcome, everybody. The presentation today is on Licensing and Registration Business Unit. It presents some overviews of the Act, where they are important for this presentation, as well as how to register all industries. Managing agent industry is one of those that was first onboarded of the other 9 industries that we were not previously able to register. And many of you will have registered using the portal on the system. That has been working well. And our only issue which we have found in relation to those registrations, just to mention before we start, is that those of you who are registering as managing agents and registering the same firm as you are registered under, or which is registered as an estate agent, may have had difficulty in obtaining Fidelity Fund certificates because our system was not did not accommodate that. If you have had that difficulty and you were unable to do that, you can apply to register under this new process, which we are doing for all other property practitioner industries, and you will be able to be issued with your Fidelity Fund certificate under this process as well, if needed. We have just this morning issued a notice which is going up onto our website to advise all our stakeholders that due to the current migration which we had in relation to our IT operations, our portal, agents portal, is not functioning correctly in that it is not sending through your documentation, etc., which was supposed to be attached and which you will have attached for your applications. So we are asking you to use the ordinary registrations email address for other queries. But you will see that in terms of this presentation, the registration of new industries is going to use the email address which I have set out herein. And you will be able to send all your queries and your registration applications under the last 9 industries, which includes managing agent industry, to this registration address if you have not been able to register previously. So we'll go straight into the change in the PPA, or Property Practitioners Act, which has now included all managing agents within the umbrella of the regulatory powers of the Property Practitioners Regulatory Authority. And you will see that we now regulate 12 categories: estate agents, the auctioneers, which operate within a regulated industry at this stage, bond and bridging finance originators, HOAs who perform property practitioner activities, as defined in the Act, that is, managing agents. Those of you who operated under the old Act will recall that in the old Act, the only managing agents that were included in the definition of estate agent were those managing agents that operated body corporate management. So if you managed body corporates under the Specification of Services Regulation published by the Minister under the Estate Agent Affairs Act, you were required to register as an estate agent under that Act. All other managing agents who managed anything else were not required to register. That has now changed, and any entity or individual who performs property practitioner activities, including managing property or any right, interest, or title in property, is required to register with the PPRA. The next industry is property facilitators and intermediaries, business brokers, including the sales of franchises and business undertakings, developers who market and sell their own developed property, timeshare and fractional ownership practitioners, property advertising platforms, property practitioners who specialize in collecting and distributing trust monies in terms of Regulation 2.4.1. These are those we call payment processing agents and attorney employees. We'll stop quickly at payment processing agents just to advise. This is entities such as PayProp, who were not regulated under the old Act. They are now required to register as property practitioners, and they are permitted under certain conditions to operate in the industry by holding trust accounts and trust monies on behalf of other property practitioners. And these they have to administer according to certain strict compliance regulations and requirements, and they are known as payment processing agents. Attorney employees have always been regulated by the Estate Agent Affairs Act and are still regulated by Property Practitioners Act. Attorney employees are defined as those attorney employees whose activities for the attorney constitute the majority of the work that they do, falling within the definition of a property practitioner activity. So if you work for an attorney and your employment duties consist wholly or primarily of property practitioner activities for the attorney, then you are required to register as an attorney employee. You should be aware that the attorney employee works directly as an employee of the attorney and performs property practitioner activities which arise within the legal practice of the attorney. As soon as the employee performs any outside property practitioner activities under another entity from another office, or such as don't arise in the legal practice of the attorney, are property practitioners. They are not attorney employees. So that's the 12 categories as defined in terms of the new Property Practitioners Act. Within the Property Practitioner Regulatory Authority, the Licensing and Registrations Business Unit is responsible for the registration of property practitioners in terms of Section 47 of the Act, and issue fidelity fund certificates as well as registration certificates. And the registration certificate is for attorney employees only. The reason for that is that the attorney employee is covered by the Fidelity Fund of the Legal Practice Council and not the Fidelity Fund of Property Practitioners. Renewal of FFCs is also administered by licensing and registrations, and you will be aware that all Fidelity Fund certificates must be renewed by the 31st of October of the year in which the Fidelity Fund certificate expires. And that the failure to do that results in the incurring of penalties. We also administer exemptions in terms of Section 4 of the PPA, and you would be aware that in terms of that section, property practitioners may apply for exemption from specific provisions of the Property Practitioners Act, and those can be granted, and a Fidelity Fund certificate can be issued if such exemption is granted on any terms and conditions contained in the exemption. Please be aware that this is a different process and a different kind of exemption to one that you would find in the Regulation 33 of the regulations, which refers to an education equivalency exemption. This is something quite different. An education equivalency exemption is somebody who wishes to be exempted from the education requirements on the basis of having an equivalent or similar qualification, which is not defined as one of the qualifications that we accept. And that application goes to the Education Department, and the Education Department is empowered by Regulation 33 to deal with that application. So please be careful to send any exemption applications to Section 4 exemptions at the ppra.org.za and not to exemptions at the ppra.org.za, because it will go to the wrong department and you will not be assisted. And then all Fidelity Fund certificates are valid for 3 years, unless the first year that it is issued is the first FFC that you as a property practitioner have ever received or have received since you have been re-registered with us. In that case, the first year constitutes the remainder of the year of the first registration, and it's valid from the date of first registration until the 31st of December of the same year. So if you are registering with us for the first time, or if you are re-registering with us for the first time, having left the industry previously, your Fidelity Fund certificate must be issued from the date on which you apply. So if you apply on the 1st of June of any year, you are required to have a Fidelity Fund certificate for that year. So that is the first year of your Fidelity Fund certificate validity. And that will operate from the date on which you register until the 31st of December of that year. Your second year will be the following year, and your third year the year after that. So in fact, you don't have a first full year, you have a pro rata year according to when you register. And this is contained in the regulations. If you look from Section 21 onwards, specifically provides this. So important information for you to have when you come into our industry and when you fall within our jurisdiction. Please note that all registration, it's not only auctioneers, everybody, it's also all property practitioners. So it would apply to managing agents as well. As with all property practitioners, no one may be registered or operate unless they are registered as a director or an employee of a registered firm. So whether you're an auctioneer or whether you're a managing agent or whether you're a timeshare operative or a bridging finance operative, you cannot be registered individually. You must be registered under a firm. And if you are a director of your own firm or a member of your own firm or a trustee of a trust that operates that property practitioner firm or a sole proprietor of your own firm, you must register your firm with us and you must register yourself as a director under that firm. A note for those of you wanting to register, property practitioner firms and their directors register simultaneously. So you do two processes, but you put them together and you submit both applications to us, because we cannot process one without processing the other. All persons who register and operate a property practitioner firm, this is now outside estate agents, attorney employees, are designated as directors, and all other persons registered under that firm are designated as employees. So as a managing agent, when you register, you will be designated as a director, not as a principal, and your employees will be designated as employees, not as full status agents or candidates or whatever the case may be. Those epithets have specific legal meanings currently as they stand in the estate agent industry, and we cannot call you or your employees the same names where your qualifications are different, your expertise is different, your nature of your business is different, and so we call all persons who register any other type of property practitioner firm directors, and employees are registered as employees. That may change as the various education requirements, etc., are changed or established and set out by the education department, but for the moment, that is what we are using. Please note that a company's directors, as reflected on their SIPC documents, must register as directors of the firm. That is in terms of the Act. A closed corporation's members, similarly, on their CK documents, must also register as directors of their firm, and the same applies to trustees of a trust. And please note that this applies unless Regulation 4117 applies to those directors, members, or trustees. And I have set out Regulation 4117 there for you. And it prescribes that where a property practitioner, that is a business property practitioner, has non-executive directors or has finance, marketing, IT, or human resource directors, or any other director who is not directly concerned with the management and oversight of individual property practitioners, exemption should ordinarily be granted from the provisions of Section 48(1)(b) and 48(2) in respect of such persons upon application being made to the authority. So what that basically says is that if you have a non-executive director or a finance, marketing, IT, or HR director, those persons can be exempt from holding a Fidelity Fund certificate with us and registering for that purpose. And all other directors must, of course, register with us and must have Fidelity Fund certificates. The exemption only applies if you apply for it, and you would do that in terms of Regulation 4. We'll talk about exemptions a little bit later. Here we come to exemptions. Section 4 permits exemptions to be granted for a maximum of 3 years, and they may not be granted retrospectively. So anyone applying for an exemption should use Section 4 exemptions at the ppra.org.za. You should also indicate from which section of the Act you seek exemption. And you will see that there's a place for you to put in on the form, E1 form. You will find that under Regulation 41.21 of the regulations under the PPA. And in that form, you need to fill in which section of the Act you seek exemption from, any motivation for your exemption that you want us to consider when the matter goes to the exemptions committee. The committee will then consider your exemption and will issue an exemption certificate in respect of any exemption that you have been granted. Practitioners should also be aware of the existence of a special type of exemption, which is a trust exemption. And this is governed by Regulation 2 of the regulations. And what Regulation 2 is, it prescribes a specific process for the granting of trust exemptions. Now, this is important because you will be aware that every property practitioner, in terms of Section 54(1) of the Act, is required to operate and maintain a trust account. So if you do not need one, and this will I would imagine, never apply to managing agents. But if for some reason or other you perform some sort of activities which are property practitioner activities and they don't require a trust account, then you may apply for an exemption from Section 54(1) by using the affidavit that is contained in the regulations under Regulation 2, and that is all you need. You don't need to do an E1 form. You just use the affidavit format. You send that to audit at the ppra.org.za, or alternatively, you can submit it with your application to register if you are not yet registered with us and you don't yet have a trust account. Another aspect which property practitioners should be aware of is issues of deregistration, dormancy, ceasing to operate, or sale of a business as a going concern, or an instance of resignation as a director. Please understand that once you come into the property practitioner industry and you are regulated by the PPA, you can no longer simply shut down, abandon, sell, or resign from your position as a director of a property practitioner within the auspices of the PPA. And the reason for that is because Section 54(9) sets out certain provisions in relation to the closing down of a managing agency or any other property practitioner firm, which must be complied with before any director or owner will be relieved of responsibility for that firm. This is irrespective of whether you resign or you are removed from the company registration documents. So in effect, what that means is if you register as a managing agent and you are the director of the firm and you decide that you are selling your firm to a new buyer, you change your name or you remove your name on the subsea documents or the business documents, and you resign as a director, that will be of no force and effect under the PPA until such time as you have complied with Section 54(9). And what Section 54(9) requires you to do is to deregister your firm with the PPRA, and by doing that, and in order to do that, there are certain things that you have to do. You have to close your trust account. You have to wind it up and submit a winding up report to the PPRA. This winding up report would be effective from the date of your last audit report that you submitted up until the date of closure of your trust account. You would be required also to submit a letter requesting deregistration. You would have to submit a bank letter signed by the bank confirming that your trust account with the number of that trust account has been closed and the date of closure. Only once that is done can we deregister you as the director responsible for that firm. And there I deal with some of the details of 54(9) to 54(14) with what is required for the deregistration of firms. Okay, you need also to remember that a property practitioner cannot be issued under any firm if the director is non-compliant. So that means that if the director of the firm has another firm which is not compliant and which is disqualified from operating due to the provisions of Section 50 or some other non-compliance, then if he registers under another firm or he registers a new firm, we will not be able to assist him and issue a Fidelity Fund certificate until the previous firm has been rendered compliant. Similarly, all employees who register under a firm can only register under a compliant firm and cannot get their Fidelity Fund certificate if that firm becomes non-compliant and doesn't have a valid Fidelity Fund certificate for the same period. All natural persons pay for Fidelity Fund certificate registration and renewal fees, and that's in terms of the regulations as well. All firms pay but are not required to pay a registration or renewal fee. They do, however, pay an admin fee on registration. Some important information on Fidelity Fund certificates. As we've said, they're issued for 3 years. All employees who leave their employer must inform the authority within 14 days in writing of their change of employment, and then they will be deregistered, or they must register under another employer. Okay? If you leave the firm and you don't tell us about it and ask for deregistration, you may attract penalties in terms of the regulations on penalties, which are prescribed by the minister. All property practitioners must inform the PPRA before the 31st of October of the previous year that they are leaving the industry in the new year, or they must renew their Fidelity Fund certificates before that date for the following year. That's prescribed in the regulations as well as in the Act. Just some information on fees, fines, and penalties. Registration fees, FFC fees, and renewal fees are established by statute. Property practitioners pay a statutory levy to the Property Practitioner Fidelity Fund on their first registration. It was initially for the 2022 year an amount of R400, which was payable over and above your ordinary registration and licensing fee. And that escalates annually, as most of the penalties and fees do under the regulations. Penalties are also established by the regulations and escalate annually according to the provisions of the regulation. As I've set out there, it's an inflation-related percentage. Fines for minor contraventions are levied by inspectors. They do this by issuing a compliance notice under sections 24 to 26. When a compliance notice is issued, the property practitioner is required to ensure that they begin complying with the notice, and they are also required to pay a statutory fine in respect of such previous non-compliance. Major contraventions are dealt with by a disciplinary process. This includes notifications, requests for a response, convening of a hearing before an adjudicator, and a sanction, which takes the form of a reprimand, a fine, or the withdrawal of a Fidelity Fund certificate in serious instances. The authority to reduce, increase, or amend a fine rests solely with the adjudicator in disciplinary proceedings at this stage. Contraventions or misconduct include non-compliance with provisions of the Code of Conduct of the PPA. And just to mention, the Code of Conduct is contained in the regulations. You will see when you look at it, it's section 34 of the regulations, that the first small section refers to all property practitioners. It relates to conducting your business with integrity, how you are expected to work, and what kind of service you are expected to provide. The majority of the Code of Conduct at this stage relates to estate agents. So that does not relate to anybody else. However, in terms of that, we are required to consult and to establish codes of conduct for all industries, which we are in the process of doing. But bear in mind that the first part of that refers to all property practitioners, and that is currently already in existence. So everybody is required to comply with that part. Some contraventions, including contraventions such as operating without a Fidelity Fund certificate, trust money irregularities, the display of a lapsed FFC, failing to return money earned while operating without an FFC when it's been requested, using the PPR name or logo without permission, etc., are all criminal offences as well as sanctionary offences. So you will find as you go through the Act and regulations that some provisions specifically state that they are criminal offences. Unlike the old Estate Agent Affairs Act, contravention of any provision of the Act does not automatically constitute a criminal offence. It did previously, it doesn't anymore. So it's only a criminal offence where it is specified as such. Please have a look at our website for fees In relation to registrations, there are a number of different categories which you may fall into, and you need to have a look at those. You will also find administration fees, which will be payable in line with a board resolution, which will be phased in shortly. Right, we'll turn to the registration process then. The director of a property practitioner firm is required to register a firm by submitting the following documents to the Licensing and Registration Department, and that's the address you will send them to: manual registrations at the ppra.org.za. And in order to register your firm, you require the business property practitioner application form completed and signed by all the directors of the firm, the company CC trust document or partners agreement showing the details of your directors, members, trustees, and partners, a bank letter signed and stamped by the bank confirming the details of a trust account which is held by the firm and stating that the account is held in terms of Section 54.1 or 54.2 of Act 22 of 2019. Please note that that must be on your letter from the bank. Section 54.1 requires that the trust account is designated as a trust account in terms of Section 54.1 or 54.2 of the Act. Alternatively, if you have received an exemption from holding a trust account, you must, instead of this letter, send us your exemption letter confirming that you have been exempted from holding a trust account. Alternatively, you can also, instead of submitting the letter, submit your application affidavit applying for the exemption. Ensure, please, that affidavits are all signed and commissioned. Please note that an affidavit is not simply a statement. It is defined as a statement that is signed by the deponent and has been commissioned by a commission of oaths. And there is a specific Act of Parliament which specifies what has to be put there, and your commission of oaths will know that. So please don't submit any affidavits that are not commissioned. You will need an auditor's letter, and that is basically a letter from your auditor confirming that we are the auditors for this particular firm. We will look at that quickly later on, just for a moment, to see where that would not apply. You also need a company resolution or CC resolution, trustees resolution, if there are 2 or more directors on your company documents, confirming who may act as principal for the firm. Now, the use of the word principal there is for use only in respect of who is the person who takes charge of or is responsible for the firm. So it doesn't have to say that the person is going to act as principal. It can be that the person acts as the principal director, or it can be that the person acts as the managing director for the firm. But it must indicate which of the directors will act as the responsible person for the company. You are also required in terms of Section 50 of the Act to provide a BEE certificate for the firm, unless the firm is a sole proprietor or a partnership. You may be aware that the definition of a BEE certificate has been in the spotlight recently. The Act refers to the requirement for a valid BEE certificate, which must be submitted. And there was some disagreement as to what the term valid meant, whether it meant valid and compliant, or whether it meant valid as far as who issues it and the period of issue is concerned. The PPRA obtained senior counsel's opinion on the matter and dealt with various entities to consult on the matter. And the result is that a BEE certificate, which is valid but not necessarily compliant, will be accepted from any firm that is a juristic person. And that must be submitted for purposes of your application. All firms, not just juristic persons, but all firms, including sole proprietorships, partnerships, and anything else, must also submit a SARS tax clearance certificate to us, which is valid for the period. And then proof of payment of any admin fees which are due. So directors register themselves individually, and this applies to auctioneers and all other forms of industry operators. They register themselves individually, so by submitting an ID document, individual property practitioner application forms completed and signed. Please note the difference. The firm was a business property practitioner application form. This is an individual property practitioner application form. The E1 form is required for exemption from Section 33 on education, which I'll look at in a moment. Your proof of payment of registration fee must be submitted. As far as employees are concerned, they also submit the application form, the E1 form for exemption from Section 33, a letter of employment signed by the director and the employee, stating the reference number of the director and the firm. So those have to be included in your letter so we can be sure to register you under the correct firm. And proof of payment of a registration fee. As stated, submission must be to that email address set out in the slide. Fees for registration, renewals, employment changes, name changes, etc. In order to register the firm, as I've said, there's no charge. The individual director pays for the registration fee for his FFC, so do employees, but the firm itself doesn't pay over and above that. All other registrations, you will find the fees on the website. Employment change is free unless you have been deregistered. Okay, so please note, if you are linked under an employer, you cannot operate and you must be deregistered if you stop operating as an employee under that employer. So before we deregister you, if you approach us and say, I'm leaving this firm, this is my new employer, here is my new employment letter, here is my new application form, please now change my employment and register me under the employment of the new firm. We will do that, and that does not require a payment. However, as I've indicated, your employees are required to advise us within 14 days that they are no longer employed by a property practitioner which they are registered under. The firm is also required to advise us of that because it's a change in the circumstances of the firm and the way it operates. So it may happen if your employees are not quick and compliant with the requirements that the firm may submit to us notification that that particular employee is no longer employed by their firm, and we are then obliged to deregister you from that firm. And if you subsequently come to us a month, 2 months, 3 months later, or whatever it is, and say, okay, I'm now working for so-and-so, that will now be a re-registration, and a re-registration fee will then be required. All right, we mentioned that we would stop at auditors, and please note that all registered directors should have a look at the audit manual that's on the website. Our audit manager has submitted a manual for auditing, which is on the website, and it's very comprehensive and it's very helpful, and it explains the provisions relating to the submission of audit reports. Now, in terms of the Act, an audit report is required to be submitted on your trust account every year within 6 months of your financial year end. The template for the audit report is prescribed by the PPRA, and it is submitted by your auditor on the auditor's portal of our website. That goes directly to the audit department, and they will evaluate the audit report for any contraventions, for compliance, and they will either accept it or they will return it with queries. Now, in terms of that annual audit report, the format to be used, most of your auditors will have, and they will know that you can send inquiries in that regard to audit, AUDIT, at theppra.org.za if you need any further assistance. The failure to submit that audit report in good time attracts penalties. And please note that if you fail to submit it, after 3 months, it becomes a non-submission, and the fine established by the regulations for that is 25,000 Rand. So it's very important that you submit that on time. And the reason for that is especially important when it comes to practitioners who operate as managing agents, because they hold so much money in trust, or alternatively, they have access to so much trust money. So it's essential that we get that audit report in order to safeguard the public in relation to the control of that trust account. All firms must have their business accounts audited within the same period, but you are not required to submit the audit or your audited financial statements for your business accounts. Those you have to keep, and you may find that if an inspector comes to do an inspection at your office, that they may ask you for copies of your audited financial statements. The proviso that we need to advise you of, however, is Section 23, which prescribes that firms who do not operate a trust account, in other words, they have been exempted from operating a trust account, or have a turnover of less than 2.5 million per annum, and those two must work in conjunction. So you must have a turnover of less than 2.5 per annum, and you must operate without a trust account, having been properly exempted from it. In those instances, the firm does not need an auditor, so you will not need an auditor's letter. And you can have your financials reviewed annually by an independent accountant and not pay audit fees. So that is something that you need to bear in mind. As I said, for managing agents, in most instances, this will not apply because you will be required to have a trust account. And this will only apply if for some reason you don't receive trust monies or you don't control trust monies, and therefore you are able to obtain an exemption. That brings us to the end of our webinar and provides, I think, the basic information. I need to advise, however, that all property practitioners should remember that they are now operating in a regulated industry. And in terms of South African law, ignorance of the law is not an excuse when it comes to failure to be compliant with the statute. So it's essential that you all have a look at the Act and the regulations and ensure that you are familiar with those that apply to you in order to ensure that you don't have any difficulties in the operating of a successful property practitioner enterprise. There are numbers, the call center number, if you have any queries, and our other operational advertising platforms, which you can look at for important information. Thank you very much.
Thank you, Advocate. I think we can take the questions now. If you have a question, please raise your hand. We will recognize you and we can ask Advocate a question. While you are sorting out to unmute, Advocate, I have a question from Declan. Can trust monies administered by managing agents be regarded in the same way as those held by estate agents?
All right, thank you. There is no change in the definition of trust money. Trust money is an absolute term. It is used in legislation and it is used in law with specific meanings. And that meaning doesn't change no matter what operations you are conducting or what industry you operate in. Trust money is any money which is not yours, which you are required to safeguard and maintain in a trust account until such time as you are lawfully authorized to pay it out or you are given consent to pay it out by the owner of those trust monies. So that is the application of trust money, and a trust account is the account in which that money is placed when you receive it. In terms of the Act, Section 54(1), all property practitioners are required to open and keep a trust account. And in terms of Section 54(3), any trust money which you receive or collect must be paid into a trust account and kept there until such time as you are lawfully able to pay it out. That trust money, that trust account must also be registered with us as the PPRA If you change your trust account, we require the bank letter to confirm your new trust account and to confirm closure of your old trust account. If you have multiple trust accounts, all those trust accounts must be registered with us in the same manner.
Okay, thank you. Okay, thank you, Advocate. I have a concern on the chat from Complex Management. He's saying we had to pay for a registration for the firm, but in your presentation, Advocate, you said it's free. So he also asking other members if they've experienced the same thing. Do you want to maybe clarify on the fees of the firm and if maybe he could be refunded if there was an error on that?
Mm-hmm. Certainly, if you were charged for an FFC for the firm, it should be refunded to you, and you should approach our finance department for that. Normally, and in terms of the Act, you pay for your FFC for the principal, and each and every principal or director or member pays for the FFC, plus employees pay for the FFC. So if you have been required to pay that as well as the firm FFC, then that is incorrect. Please note, however, there's one aspect which I can perhaps touch on, which may explain something like that. You will recall that in the regulations there is a provision which says that if you operate in the same industry under multiple firms, and you can only do that if you're a director of those firms, not an employee. But let's say you're a director and you have 3 different managing agent firms, and this is all in the same industry. The regulation says you actually only need one firm, or one FFC as an individual to operate in that industry. However, it also says that each and every firm must have a Fidelity Fund certificate. So your registration under each firm will require you to pay for your FFC for that firm, whereas your own individual FFC, or rather, whereas the firm's FFC, you do not pay for. So you get one for yourself, and you'll get one for the firm. You may not need to use it. You don't need more than one, but you cannot register that firm, and that firm cannot be given a Fidelity Fund certificate if you don't have one in your individual capacity under that firm. Okay.
Okay, thank you. Before I go to the hand, maybe let me take a last question on the chat and we will come back. I have one from Kim. Advocate Vile says valid document. When we did the original submissions in 2023, we got new bank confirmation letters, auditors' letters, etc. How old may the documents be? Or do we have to go to all these places again to redo all the work we did? So I think she's referring to the documents. If they have to register now, do they need to resubmit fresh documents?
In some instances, you will. Your ID document is no longer required to be certified if you submit it online, and that's simply because a certification on an email or a non-physical, non-hard copy is not of any value. It could be a photo of anything that is not, as far as the certification is concerned. So as long as the ID is a valid ID, and we will get that from your ID number, then you can submit it to us without certification. So the certification is no longer an issue when it comes to the ID document. Your employment letter must be less than 6 months old. And the reason for that is that when you send it to us a year later, and it refers to the previous year, we need to be sure that you are still working there, and things haven't changed since then. So in instances such as that, you will need to get another letter that simply has a new date on it, to confirm that the status quo is still the same. Your application fee, your application form, if it was submitted to us already and the application form was submitted on a specific date and it was valid on the date of application, that will be sufficient. We will not require you to do it again if in our systems, because we're aware of the fact that in trying to now regulate the 12 categories when we're used to regulating 1, we've had to develop our system hugely in order to accommodate this. And obviously that is a process. It takes time, it takes testing, things get done, and then we discover that there's a glitch or there's a problem. And sometimes we have documentation that comes in, applications that come in, they are not found anywhere, they don't get to us because the system doesn't show them and they get hidden somewhere on the way. So where that has happened, we do apologize, but unfortunately it does from time to time. Then if we can see from your submission that that was submitted and your documents were valid at the time of submission, we will certainly note that and we will accept those documents.
Okay, thank you, Advocate. Let me go to the hands. I see Peter. You can unmute yourself and ask your question.
Thank you, Naledi. Thank you, Advocate Val. Advocate Val, we submitted our initial application in February. The emails that I've now received back in the last month is that our documents are out of date. Now, you've just mentioned that you will accept the previous documentation
Yes.
for the submission. Would you please communicate that through to your staff? Because I certainly don't want to get new documentation right now when our original application was correct.
Please, yes, certainly. That is a change that we have communicated. As I say, sometimes change takes a bit of time to sink in, but I'll certainly look into that. Please be aware that when you have submitted it, it may be that they haven't been able to see from when they got the documents, when the documents were submitted, and so you may get a query like that if they are not able to see it. Hopefully, there will be something that indicates it. But if you are querying it now and you get something like that, please just respond and say, this is when I submitted it. In terms of your webinar, that is sufficient because I submitted it and it was valid at the date of submission. So,
okay, I'm going to send that email
look
right now because I received that email back about, I don't know, 3 weeks ago, and I'm obviously trying to get the new documentation for that, but I'm just going to send an email then. And then, sorry, just a secondary question. We also received confirmation over email from one of the staff that we need to submit an E1 form for all of the directors to seek exemption from the educational requirements. Do we still need to do so?
Yes, you do need to do so. I think I did mention that, but I said I would touch on it more, and I don't think I did. Perhaps I can just mention it for everybody at the moment and explain what this means. In terms of the Regulation 33, this deals with education requirements required for property practitioners. Now, you will be aware that there is currently educational requirements that exist for estate agents. And those are in terms of an old regulation under the old Act, the regulation on standards of training for estate agents, which was issued in 2008. The Education Department has perpetuated that requirement under the new Act. The new regulations specify that the PPRA must establish standards of training for each and every industry. We must also establish a practical training course for each and every industry. And we must establish a professional designation exam for each and every industry. It also says that every industry has to do CPD, which is continuous personal development in the profession in which you are in, and we have to provide that CPD for you. And there are certain conditions that attach to that. Now, currently, the Education Department has not yet finalized standards of training or PDE requirements, that is the professional designation exam requirements, or a practical training course for any industry except estate agents. So that means it's not possible for you to comply with any education requirements because there aren't any. However, the difficulty that we have is that Regulation 33 says that no person can operate as a property practitioner if they haven't done a practical training course and written the PDE exam. So we have to exempt you from the requirements of that regulation because we can't yet offer you a PDE exam to write, and we can't yet offer you a practical training course to do. So that's why every employee and every director, as a matter of form, submits an E1 form. The E1 form is that exemption form that I mentioned. It doesn't require you to do motivations and reasons and references, etc., which an ordinary exemption application would require. All you need to do is fill in the form, ask that you want an exemption from Regulation 33, and the reason that you give is that there are not yet any requirements available from the PPRA as to compliance with the education requirements in Regulation 33. And you will be granted that exemption as a matter of course. And those can come in with your application for registration. They will be sent to the education department, to the exemption department, and they will deal with it. Yes.
May I perhaps make a comment on that? Wouldn't it just cut down substantially on your checking and the documentation needed if you obviously just give blanket exemption to the managing agent industry, that these E1s don't need to be submitted at this time, because otherwise you need to go and check everything. It's just going to cut down on the processing from your side, because
yes,
everybody
absolutely.
needs to then fill it out. If you can just give the blanket exemption, then it will work.
The problem is we cannot, in terms of the Act, give any exemption unless there's an application for it.
Okay.
And that's our problem. So if you would like to get NAMA or whoever to do a blanket an application for all managing agents, saying, please, will you exempt us from Regulation 33 for 3 years, alternatively, for the period which it takes for us to be able to allow you to qualify, then I'm quite sure that our exemption department would be very happy to consider that.
Excellent. Thank you so much. Appreciate it.
Thank you, Advocate. Let me go back to the chat. I will come back to you, Complex. I see your hand. Charmaine is asking, what is an F1 number that they ask for on the employment letter, Advocate?
Okay, an F number, it's not an F1 number, it's an F number. And the F number is your firm number that you are going to be employed under. So if it's an estate agent firm, it will be F123456. If it is a managing agent firm, it will be MAF 123456. Your individual number will be MA 123456. So it depends on the employer has the MAF number, the employee and the director or the mentor has the MA number.
Okay, thank you so much. I hope it gives clarity. I also see chats from Kim van Niekerk, and I sense some frustration. Can I propose, Kim, that you send us an email with all the complaints that you have, and also maybe tell Advocate who's the person who was assisting you, so that Advocate can call that person and see why there was a delay in helping you, hence the frustration we're seeing on the charts. Let us help you today. You can email me. I dropped my email. It's on the pin. Advocate's email is also on the pin. Please also give us the names of the people you dealt with, and Advocate Vile will handle it as the executive in licensing so that we can assist. Let me go to the hands and take a question from Complex. Please unmute yourself.
Hi, good afternoon, everyone. Thank you for letting me address my questions. Just a quick one with regards to the exemption application for the educational requirements. Is there going to be a fee attached to that because we don't have any other option, or is that something that would be done for free?
The exemptions, I believe there is a fee that is required to be paid for an exemption application, and it's in the provisions, or it's in the admin fee schedule, which is on the website. Okay. So I'll just check and make sure it's there, but I believe there is a fee for exemptions. Yes.
Okay, that's fine. Then I think going back to Peter's queries earlier, I think it might then be better to do a blanket exemption, because we are being forced to be exempt from the educational requirements because of the fact that there are no current requirements for managing agents. But then in order to comply with that exemption, we've got to pay for it. Meanwhile, it's not out of our choice. So I don't feel that that was very fair on the managing agent side. And then my next query is, the company was formally registered as a real estate company because of the requirements prior to December 2022. We had just done our renewal of the FFC in that year for October, which is then, of course, valid for the 5-year period, but then a few months later, 2023, sorry. But now a few months later, now we've got to get our managing agent firm FFCs, otherwise we can't practice legally. So now what happens in a case like that where you were registered previously under one category, but you've now had to change your registration. And of course, then it's the directors and all of the staff as well that would have to change their industries, basically. Do we have to change employers for our employees, or is it a simple swap over? How is all of that affected?
Okay, in terms of the Act and the regulations, you need to register separately and obtain a separate Fidelity Fund certificate for every industry which you operate in. So if you operate in the estate agent industry, you have to have an estate agent FFC and you have to be registered under the estate agent industry. If you also operate as managing agents, you have to be registered in both managing agent and estate agent industry and have separate FFCs for each and every one of them.
Okay. And how do we deregister? Sorry, just while we're on that point, how do we deregister as a real estate agent then?
You deregister as a real estate agent as set out in section 54.1, which 54.9, sorry, which I dealt with in the slides.
Okay, perfect. Thank you.
Thank you so much. Let's go to Gert.
Deborah, I just want to ask if you've done your registration or sent through your documentation to registrations at the ppra.org.za, must you resubmit them to manual registrations?
If your registration is not yet through, there may have been a problem with the registration of the firm under the system. I don't know if did you have an estate agent firm before or not?
The firm has already been registered as well as the director, so this is for an employee.
Oh, is this for an employee? Yeah, I would suggest you do, simply because at the moment we have an issue with our portal, and our portal is going to close for a period until they've resolved the problem. We recently did a merger, and there's a notice going out to this effect, as I said. And the migration that we did in relation to the what is called our paper trail, which is our document storage receptor on the system, is not working. So it's not pulling your documents through. So I would suggest you do send that to. In fact, don't send it to. It depends. Are you registering? You want to register your employee as a managing agent?
Yes.
Yes, okay, that's fine. Yes, do it through the manual registrations email address, and they'll be able to assist you there.
Thank you.
Okay, thank you so much. And the manual email address, it's on the presentation that Advocate gave. We also emailed to you. You will see the email addresses. Let me go to the chat. I will come back to you, Jackie. I have Edith on the chat. She's saying, if you have been exempted for trust account, what submissions does an auditor still need to submit on behalf of a managing agent?
The auditor is not required to submit anything on behalf of the managing agent. If you have no trust account, you are not required to submit a registration, an audit report in respect of that trust account. And you are also not required to submit your audited financials, even though you may be more than the 2.5 threshold. You don't submit them, you have them completed, and you have them audited, and then you keep them. Those are your financials for your business statement. But I'm not sure if you were exempted from holding a trust account as a managing agent. Do you not receive trust money at all?
It's a chat. Edith, please come through, raise your hand. Let's have a discussion on that because she wrote it on the chat. Please come through, Edith, unmute yourself. Okay, maybe she's struggling to unmute, Advocate. I see her hand. She can unmute it.
Yes, Naledi, I have been
Okay.
exempted from having a trust account because all our body corporates have their own bank accounts. So we don't have any trust monies going into the trust fund, the trust account.
Okay. Does it go directly into the body corporate account?
Yes, yes.
Okay. All right, fine, thanks.
And we have the letter from the PPRA for that exemption.
Yeah, no, that's fine.
Okay, thank you.
Okay. Hey, Jagu, please unmute yourself.
Thank you for giving me the opportunity to speak. My question is regarding all the places we must send this documentation through. So the first time I sent it through was in 2023. Then in 2024, March, I went through to Jolene, which Jolene sent it through to Lizzie, which then sent it through to registrations, when sent it through to Mungiswe, as well as Jolene sent it through to Deborah Val directly as well, and to Lizzie again in April. I personally have sent through the documentation to manual registrations at the PPRA. The last time I followed up was on the 7th of August at 20:27 at night. And to date, I have not received any confirmation, anything that they've received it or looking at my email or even a smoke signal. We get nothing back. And when we speak to NAMA, nothing happens as well. So
All right. Can
what
you
is the
give me?
purpose of this thing if we have to send stuff again to manual registrations, and we have done this on numerous occasions?
Okay, I apologize for that. Can you give me your email address so they can find your documents and I can ensure that it gets done?
Thank you. It's Jock at Morite, JACQUES at morite.co.za, MARITE.co.za, but I'll send you an email too.
Right, thank you. All right, I will follow that. Can I have your cell number?
083 234 3740.
234 3740.
40.
Okay, I've got it. All right.
Thank you very much. I have to
I'll make
jump
sure
off.
something happens. Okay.
I've got a meeting. Thank you very much.
Okay, thank you for your question. Let's go to Renske. Hopefully I'm pronouncing your name correctly. Please unmute. Please unmute. Okay, let me go to the chat.
Hi,
while
can you hear me?
Okay, yes.
Hello, can you hear me?
Yes, we can hear you. Please ask your question.
Hello?
Yes, we can hear you.
Okay. Great, thanks. I've got exactly the same situation as Jock. Also been trying to get registered since March, and I've got hundreds of reference numbers and emails, and I'm just not getting a response.
Okay, please just give me your email address and your cell number and I'll have them look into it.
Sure, it's Renske. It's
Please put it on the
RENT.
chat, sir. Sorry, sir. Please put it on the chat and I will email it to advocate.
Okay. Thank you. Will do.
Lady, I'd just like to take it down now as well so I can get this expedited. You said Renske at?
It's typed in the details in the meeting chat.
And your cell number?
There you go.
Thanks.
0833 774133.
Thanks.
Okay, advocate, I have Chantel. She also has the same problem. She put her email here and the cell phone number. Let me send you email now. And I have a hand from Serena. Serena, please ask your question.
Yes, good day. Sorry. I know that all the managing agents had to register many years ago as an estate agent. Now on this platform, I would just like to ask Deborah, out of all those that were registered as estate agents that are now trying to register as a managing agent, I'm not talking about new managing agents, can you confirm if anyone has received an FFC stating on the FFC that they are registered as a managing agent that used to be an estate agent?
Yes, we have issued some. We are in the process of issuing quite a lot more. We've had a lot of incoming applications, but there have been some that we've issued, and some people have had no issue with getting theirs. So it's just, unfortunately, we're a bit swamped at the moment. We spent about 2 weeks without our email platform when the migration was done, so there's been a backlog there. Previously, you will know that we lost 15 of our staff members in the licensing and registrations department. So we've had to train new people, and certainly we got rid of the backlog, and it's now developed again as a result of various internal issues. So we do apologize for the fact that there are delays. There are going to be delays, unfortunately, but we are doing our best to get through them. But yes, we have issued fidelity fund certificates for managing agents, some of them without any difficulty.
So if anyone on this group has received their FFC, if I could just ask them to put their email address and their name and a big thumbs up in the chat so that we can contact them and find out how they did it. Because I think the majority of us are on this meeting now because we are unable to. And Deborah, you'll know backwards and forwards, you've been dealing with me as well as some of your other staff. And I have not yet spoken to anybody, including any member of NAMA, that is able to get their FFC as a managing agent who used to be an estate agent. And none of us have even started the deregistration as an estate agent process, because that's another thing. You can't close a trust account if you have a trust account. You know, you can't deregister one agency because the change of what you are called and under the PPRA, whether you're an estate agent or managing agent, you still have the same clients, the same bank accounts, the same company number, and the same everything. You can't go and deregister it and close your trust account. So I think that requirement in terms of the steps that you have to go through to deregister as an estate agent needs to be looked at as well, please.
Unfortunately, that's a provision of the Act, which is an Act of Parliament, so we don't have the ability to change it, and it's unlikely that the Minister is going to get any change through Parliament anytime soon. It's a process that takes 5 years, if you're lucky. So that provision is going to be there. What we can do, which is not going to be difficult, is that we can ensure that if you want to deregister your current firm, but you're going to be, and I've had many of these, but you're going to be registering and keeping the same trust account for your new managing agency, then there's no difficulty with us simply noting the same one there and noting that that firm has been deregistered and the trust account transferred to the new firm. So we've done many of those because there are those who want to register their managing agent company, and it was the same company as the old company. So that's what we do in those instances. We simply tell you to provide us with proof that this is now your trust account in relation to the firm. And if it's going to be the same as the previous one, we will then make a note of that if you give us that kind of a letter confirming that.
Understood. It's unlikely that we will be able to deregister that firm before October. And that means that we will have two firms, and I trust that the PPRA won't be penalising or charging late penalty fees for a firm that is going to be dormant. It just can't be done yet.
Sorry, I don't understand what can't be done yet.
Well, we can't deregister the firm yet because we're still waiting for the FFC for the managing agent's firm. At the moment, at least we have one FFC that's valid. Am I not making myself clear?
I want to check. I think she got cut. Sorry about that. Just give me a... I'm sending her the link on WhatsApp.
Okay.
So she can quickly join back. Sorry about that.
And then, lady, are you maybe able to answer the question? Are we able to deregister the firm for the managing agent as registered as an estate agent before we get the FFC as a managing agent?
No, on my side, I won't be able to confirm because I work only with the marketing departments for organizing the webinars, workshops, seminars. So most of the things that they are teaching, I'm also learning them as and when, or especially on the new regulations and legislations. So I have advocated to confirm that because she's the executive in the licensing. I sent her the link. She's going to join now.
Thank you.
Serena, you've already frightened Advocate Deborah away. Please don't frighten Naledi away.
No, I'm here. I'm here.
Derek.
Just for interest sake, Serena, I went to the PPRA's offices about 2 weeks ago.
Yeah.
I handed in my forms manually. I spoke to a lady called Sia. She submitted everything, and about 4 days later, I got an email saying I've been registered and here's my MA number, and I will get my FFC on the portal in 10 to 14 business days. I think that's in about a week from now. Hopefully it'll be on the portal.
Please let me know if that's the case.
Okay.
Yeah, that'll be
I think
great.
she's back. Let me see.
Okay.
Oh, yeah, I think sometimes it helps to come to the office and sit with a consultant so they can do your application from scratch. And when you have a query, they can answer it right there and then for you.
Where are you based, Naledi?
We are in
Sandton.
Sandton, yes, and in Cape Town, we also have an office. We shared it on the chat. It's on our website as well.
And in Durban?
We still are going to establish a satellite office. I know the process is ongoing to open the Durban one.
And Port Elizabeth?
Not yet. Not
No,
yet.
not yet. Okay, sorry everybody, I was kicked off and my laptop's still deciding whether it's going to let me do anything. So I've joined on my phone, so I apologize for the interruption.
Sorry, Deborah. So the last question is, are you saying that we can start the process to deregister as an estate agent, even though we don't have the same firm names registered as a managing agent and an FFC yet?
Sorry, I'm not quite with you. Just repeat that.
Okay, so we have to, you're saying once we get the FFC as a managing agent, we then got to deregister as an estate agent. But because it's taking so long to get an FFC and get registered as a managing agent, are you saying that we can start the process to deregister as an estate agent now so that we don't have to pay for 2 firms to continue until we have at least one valid FFC for one?
If you are not operating as an estate agent, yes, you can, because your estate agent FFC doesn't allow you to operate as a managing agent anyway. So it's of no value to you if you're not operating as an estate agent.
All right, so we can start the deregistration process with that.
Yes.
And we will still be acting lawfully, I assume.
Well, in terms of the Act, we're in a transition period where we are now registering you. And on the basis of that, we don't have an issue with you acting until such time, as long as you've applied and we are in the process of issuing your FFC, that's fine until you get your FFC. As long as you're in compliance and you've got everything, you've submitted everything, we haven't gone back to you and said, listen, you haven't done this or you haven't done that, and you've ignored it, in those circumstances, you're fine.
Okay, thank you.
Thank you, ma'am. I don't see any hands. I got the email addresses on the chat, Advocate. I'll email you so they can look for the applications.
Yes, please. Thank you.
Yes. Do we have maybe any comments, any questions before we close the webinar? And all the chats I will send to Advocate Vile. She's going to respond. We're going to download the recorder. We're going to put it on our YouTube under the PPRA TV channel. We're going to have another webinar on the 13th of September with all the categories, including managing agents. We are going to issue out the link on our social media. Please look out for that. The presentation we did share with NAMA to email everyone. If you're still looking for a presentation, we can also share with you. You can email me. I've pinned the email address for myself and for Advocate Vile. You can find it there. She's going to assist. We know that previously you did email the former executive, Jolene Wasserman, is no longer with PPRA, and we really do apologize for this delay and frustration. But I do know that she's going to deal with it. Advocate, she has a team of people now because she was short-staffed, but now there's people in the department, and all the queries that we're going to get, we're going to send it to her to prioritize it so that we can help you so you're able to trade. Advocate, thank you so much for the presentation today and taking all the questions. If we get more questions on my email, I will forward you so that you can assist us with the reply. And please look out for the dates of the next webinars. Thank you so much. Thank you, colleagues, for joining the webinar. Bye-bye.
Thank you. Thank you, everyone.